Okay, good afternoon. And on behalf of the Canadian Council of Muslim Women, welcome to CCMW's Inheritance webinar. We are now going to get straight into the housekeeping rules. So thank you again for taking the time out to join us today. My name is Sabrina Azrak, and I'm the National Projects Coordinator at CCMW, and I will be your moderator for the duration of this webinar. Before we begin the webinar, let's go through some housekeeping rules. So today's webinar is being recorded. The recording of this webinar will be available afterwards on our website at www.ccmw.com. We welcome you to revisit the content yourself and to share it with your networks. It will also be uploaded on our YouTube channel. Please ensure that your video camera and your microphone are muted and turned off throughout the duration of the webinar. This will help eliminate ambient noise and increase clarity. We invite your comments and questions and will run a live Q&A session at the end of the webinar using the chat box. The chat box button is the sixth button from the left at the bottom of your screen. Once you click on it, the chat box will appear on the right-hand side of your screen. If you think of a question at any point, just type it into the chat box and I will pose it during the Q&A portion. You could choose to ask the question anonymously by sending the message to myself, the host, or you can choose to send it to everyone. An evaluation will be emailed to you later today. It will take about 5 minutes to complete. Please don't include your name on this form in order to maintain your privacy. The information you provide will be kept confidential and private. Only authorized individuals at CCMW will have access. If you require any technological assistance, please send me a direct message using the chat box, or you can send me a text message at 416-897-1907. And now for CCMW's vision and mission. The Canadian Council of Muslim Women is a national nonprofit organization committed to attaining equality, equity, and empowerment for all Muslim women in Canada. Founded in 1982, the organization works to promote Muslim women's identity in the Canadian context. For more than 37 years, CCMW has proudly advocated on behalf of Muslim women and their families and developed national projects that enrich the identity of Canadian Muslims, encourage civic engagement, and empower communities. During the past several years, the Canadian Council of Muslim Women has undertaken initiatives to inform Muslim women, the legal profession, community service agencies, policymakers, and the general public about the differences between Muslim family laws and Canadian family laws. Previously, CCMW published Muslim and Canadian Family Laws, a comparative primer in both English and French, as well as a series of booklets in several languages on family law topics to further its public education efforts. Our latest national project in this field is the Muslim Women's Family Law and Legal Rights Project. In this project, we update these documents and disseminate them via knowledge-sharing workshops within different cities across Canada for Muslim women, community service providers, the legal profession, and the general public. So these knowledge-sharing workshops have been halted due to the COVID-19 pandemic, but will resume or if we are able to, or we will continue to use these webinars as a way to disseminate this information. In 2003, CCMW took the lead in establishing a coalition against religious arbitration, composed of over 50 sister organizations, including the National Association of Women in the Law, METRAC, and the YWCA. The No Religious Arbitration Movement and CCMW's work represented an array of complex issues and events. We were successful in that the Government of Ontario made a decision to disallow the use of religious family laws under the province's Arbitration Act. CCMW advocated for one set of laws to be applied to all, regardless of faith, ethnicity, race, or culture, under the existing family law legislation. CCMW believed that the use of religious laws through private arbitration to settle family matters under the Arbitration Act violated the hard-won equality rights guaranteed under the Canadian Charter of Rights and Freedoms and had the potential of creating a two-tiered, fractured justice system. CCMW was compelled to inform Muslim women about the choices they have available to them within Muslim and Canadian family laws and simultaneously educate individuals and institutions that assist them or work with them to resolve family disputes. CCMW is composed of a national board that works to further CCMW's objectives at a national level, as well as 15 local chapters made up of incredible members whose passion and hard work advance the vision of CCMW within local communities. To learn more about CCMW, please visit www.ccmw.com. I'm now going to turn it over to Pamela Cross, the facilitator for today's webinar.
Thank you very much, Sabrine, and hello to all of you who are with us this afternoon. Welcome to this webinar, excuse me, which is produced by the Canadian Council of Muslim Women. As Sabrine has said, my name is Pamela Cross. I'm a lawyer. I work with a wide range of violence against women and women's equality organizations, primarily in Ontario, but also elsewhere in Canada. I've worked with CCMW on a number of projects over the past several years. The focus of my work, whether with CCMW or other organizations, is on the issue of violence against women and the law. Also joining us today is Professor Omar Farhat, who with me was responsible for revising the brochures on which these webinars are based. And you won't hear much from him in the first part of this webinar, but he will be participating in the Q&A that we will be having at the end of the webinar. I'm honored to be facilitating this series of 7 webinars, which reflect the content in 6 brochures, as you can see on the screen, that were produced by CCMW and that provide comparative information about Canadian and Muslim family law, particularly as they pertain to women's rights. The topics covered in those brochures are marriage, divorce, custody and child support, family property and spousal support, domestic contracts, and inheritance, which is what we'll be talking about today in our final webinar in this series. For any of you who've been unable to join us for the preceding 6 webinars, all of the webinars will shortly be posted on the CCMW website. So if you missed any, you can listen to them there. If you participated in all of them, but you want to refresh your memory about something, you can go back and have a listen to either all or part of one or more of these webinars. The goal of the written materials, as well as the webinars, is to assist Canadian Muslim women in being able to make informed choices in the area of family law in Canada. We hope the resources will also be of assistance to professionals who work with Muslim women who are involved in the family court system, to students who'd like to know more about these issues, and to community-based services that assist women. The content of these webinars is based on an earlier resource produced by CCMW, published in 2006, called Muslim and Canadian Family Laws, a comparative primer that, as I say, was published by CCMW in 2006. Please note that the information contained in these webinars is just that. It's information. It's not legal advice, and it should not be interpreted as such. If you or someone you know is dealing with a family law issue, it's important for them to meet with a lawyer to discuss their situation, to provide the lawyer with all of the details about the family, and then to receive legal advice. The webinars, the brochures, and the primer, which we certainly hope will be helpful to you, are not a replacement for legal advice. If you want to find out about the sources and validity of Muslim laws and legal opinions referred to in these webinars, you should consult the resource I mentioned earlier, Muslim and Canadian Family Laws, a comparative primer. Laws in a public legal system are in a constant state of flux as they change to adapt to the times. What you hear today, what you read in the brochures, is accurate in the case of the webinar to today's date, and in the case of the brochures to the date they were published. We strongly encourage you to verify that the information is current at the time you're reading it or hearing it. At the end of my presentation, which will be a bit shorter than the earlier presentations, but that's okay because we think there will be lots that people want to talk about in the Q&A session, we will take time for questions and answers. As Sabrine has said, you can pose your questions by writing them into the chat area on your computer screen, Sabrine will then read the questions out so everyone can hear them, and then Omar and I will do our best to answer them. And I encourage you to enter your questions as you think of them. Don't wait till the end of the webinar because you may forget something that you were thinking about earlier. Muslim laws of inheritance are among the few areas of law that are addressed by relatively detailed Quranic provisions. Perhaps one of the most striking features of Muslim inheritance regimes is the relatively limited role of bequests, which is limited by law to a maximum of 1/3 of the deceased's estate, following payments of all debts, including any delayed dower and any funeral expenses. After payment of debts and bequests, the estate is divided in shares of 1/2, 1/4, 1/8, 2/3, 1/3, and 1/6 among a group of specific blood and marriage relatives that follow these detailed Quranic injunctions. In general, and we'll talk a little bit more about this in a few minutes, males will receive double the inheritance of females who are in the same category. The Canadian system is quite different. In Canada, the manner in which people can determine what happens to their money, their property, their belongings after they die is governed by provincial laws. In Ontario, that law is, in particular, the Succession Law Reform Act. Individuals are free to leave instructions via a will to have their property disposed of in any way they wish. However, if the will fails to provide for dependents, including a spouse and non-adult children, it may be possible to challenge it. And we'll talk about that in a few minutes. When one spouse dies and leaves a will, the surviving spouse has the right to take the property as it's set out in the will, or to receive their entitlement under the Family Law Act. And we'll come back to that in greater detail in a few minutes. Let's explore the female half-share rule. This is established in the Quran, which contains an unequivocal injunction. That in turn makes it difficult to reverse in Muslim law. However, parents of daughters have generally found many ways to increase their daughters' shares, either through bequests or the establishment of trusts with the daughters as beneficiaries. Another option is to divide a portion of the parents' property among the children while they're still alive, which means it's of course no longer an inheritance, and the rules, the half-share rule in particular, doesn't have to be followed. The half-share rule only applies to males and females in the same category. In other words, sisters receive half of what their brothers receive. So it does not mean that a daughter would inherit half as much as an uncle or a grandfather, for example. Many explanations of the half-share rule have been put forward over time. Some of them are historical. Historically, men were the primary breadwinners, as well as the providers for their families. But of course, that's no longer necessarily the case. Others have argued that, like many other things, the Quran was attempting to reach an ideal of gender equality in a gradual manner, since in 7th century pre-Muslim Arabia, women did not inherit at all. In all cases, it's understood that the Muslim inheritance system is deeply rooted in a reformist attitude towards the tribal practices that were predominant before Islam, such as withholding inheritance from daughters, distant relatives, and generally the more vulnerable. The intricate system of inheritance was designed to ensure that those who control the estate do not get to dispose of it as they please in an arbitrary manner. In modern Muslim majority states, most continue to apply the female half-share rule, although some, like Tunisia, have begun to develop an egalitarian regime. And as I mentioned a minute ago, parents can find ways to get around that half-share rule without violating it by setting up trusts or disposing of some of their property while they're still alive. There is no equivalent to the female half-share rule in Canada. People can dispose of their assets however they wish through a will. In other words, if someone chose to, Their will could stipulate that the daughters received less than the sons, or that the sons received less than the daughters. Their will could say that the children get none of the property whatsoever. So there's no formal structural framework that says you must give this much money or this much of your property to this person compared to that person, and so on. Non-Muslims do not receive inheritance in Islam. The same goes for stepchildren. Since Muslim law does not recognize adoption, any children cared for by the deceased, before they were the deceased, obviously, who are not biological descendants can only inherit through bequests. Under Canadian laws, anyone may be specified in a will to inherit all or part of an individual's property. In other words, while it wouldn't be a very nice thing for me to do, I could write a will that left nothing to my children, nothing to my partner, had left it all to a stranger I had met on the street the week before I died. Since adoption is legal under Canadian law, adopted children are considered to be dependents, just like that biological children are, and can also inherit. There is also no legal distinction between children who are born inside or outside marriage. I'm sure everybody's familiar with the term illegitimate children, meaning children who are born to people who are not married to one another. That term has no legal meaning in Canadian law, and including Canadian inheritance law. Under Muslim law, a will is not required, but it's valid within the limits of 1/3 of the estate. That is, the value of the estate addressed in the will cannot come to more than 1/3 of the total estate. In other words, if my estate, if everything I have, my house, my car, jewelry, bank accounts, comes to a total of, let's make it easy, $330,000, under Muslim law, my will cannot speak to more than 1/3 of that, $110,000. Under Canadian law, for a will to be valid, it must be in writing and it must be signed by 2 witnesses. There is one exception to this, and that's the holograph will. A holograph will is a will that's been written entirely by what the law calls the testator. So that's the person who's writing the will. If it's written entirely by that person in their own handwriting, then it does not require a witness. And I want to stress this, the entire will must be written in the person's own handwriting. The person can't type it into their computer and print that off and then sign it. That's not a holograph will. The whole will must be in handwriting. And I'm stressing this because often people think, well, it's just the same. I'll just type it on my computer and then I'll sign it. It's my will. I know it's my will. But of course, the problem with that is that it would be easy for somebody who was trying to manipulate the outcome of the will to type out something different than what the person actually wanted, have them sign it surreptitiously or dishonestly, and so the person has signed something. If I write my entire will in my own handwriting and I sign it, let's say, then I die, the will surfaces, somebody wants to challenge the will because they don't think it's what I intended, they would have to establish that that was not my handwriting. So a holograph will is a will that is entirely handwritten by the testator, the person writing the will, in which case it can be signed just by that person. Otherwise, there have to be 2 witnesses who sign the will. Under Canadian law, a will is automatically revoked if the person who's written the will gets married or divorced, writes a new will, or even if they give written instructions to revoke the will. So let's look at each of those different situations. Let's say I have a will and then I get married. I need to write a new will, even if it's exactly the same. I need to write a new will after I get married. If I do not, my existing will, written before I got married, is not legally binding. And this actually happened to an acquaintance of mine not long ago, an older woman who married late in life. And she knew she needed to rewrite her will, but she didn't get around to it. And she died. And then there was no will from a legal point of view. Even though there actually was an older will, she likely wouldn't have made significant changes to it, but it was as though there was no will at all. The same is true if somebody who has a will gets divorced. They need to write a new will. International wills are recognized by Canada if they're properly executed. In other words, they're in writing and they've been witnessed. Under Canadian law, there are a number of grounds on which a will can be challenged. First, if the person was unduly influenced by someone to write the will in the way that they did. For example, a benefit was withheld or a threat or promise was made. It's not too difficult to think of examples of this kind of situation. Of course, we hope they would never happen, but certainly these situations do come up, especially for people who are older, who perhaps have become dependent on one of their adult children, and that adult child takes the opportunity to manipulate the aging parent to see the other siblings as less deserving of the money. And so then the parent writes a will that reflects favoritism towards one child. Or perhaps that adult child says to the parent, you know, I've been doing all of this for you. If you don't indicate that in the will by giving me more of your money, then I'm not going to be here for you. I won't take you to your doctor's appointments. Perhaps the adult child promises to move in with the parent and care for them if the will is written in a way that's favorable to that adult child, and so on. I mean, there's countless ways that somebody, and it doesn't just have to be an older person, that somebody can be unduly influenced by someone else. A will can also be challenged if the person writing the will lacked the mental capacity to prepare a will. And again, because we tend to think about older people when we think about wills, that would include somebody who has dementia. They do not have the capacity. But it could also be because the person has a developmental disability. It could be because the person has had a stroke and doesn't have the mental capacity any longer to indicate what they want to have happen with their property when they die, and so on. If the will has significant mistakes, so we're not talking about a comma instead of a semicolon, but where people are misidentified when the value of the property or the identification of the property is extremely incorrect. If the will does not meet the formal requirements that it be signed, that it be in writing, signed, and witnessed, then it can be challenged. If the will fails to provide for the spouse and or for dependent children, it can be challenged. I'm going to come back and talk about that one in a couple of minutes separately. Or if the intentions of the person are unclear. In other words, if the will is so vague that it's impossible to understand what the person was intending to do. All of these are reasons why somebody can challenge the will. Who is that somebody? Well, it's usually somebody who thinks they should be getting more than the will as it's been written would give them. In a large family, for example, let's say the mother writes a will, the father's already died, that leaves more of the money to the youngest child because that child's really had some trouble getting started in adult life, is working hard, but just doesn't have the financial security that the other sibling or siblings have. Those other siblings might think, well, that's not fair. We should have each got the same amount. And they might think they can challenge the will. But if they want to have any hope of success at all, they're going to have to show that their mother was unduly influenced by that youngest sibling, that she lacked the mental capacity to prepare the will, that there were mistakes in the will, or that it doesn't meet the formal requirements. Otherwise, if they challenge the will, they will in all likelihood be unsuccessful because you cannot challenge a will simply because it is unfair. In Canada, people can write unfair wills if they wish. Oops, sorry. For example, a parent can write a will that, as I suggested, leaves more money to one child than to another. If they're all adults, that's not a problem. If one of them was still a dependent child, then that individual would have the right to challenge the will. as I said a few minutes ago, a parent could even write a will that didn't leave any of their money to anybody. And there have been many very sad stories along these lines where later in life, a parent who's lonely gets manipulated by an individual outside the family. Sometimes it's somebody who's hawking a particular charitable cause. It might be somebody who's persuaded the parent to join their religious group, and the parent becomes manipulated / persuaded to leave their money to this entity rather than to their children. Certainly the adult children could challenge that will, but it's a high standard, and there has to be clear evidence that the parent was unduly influenced, as opposed to they had a change of heart later in life. These kinds of conflicts also come up when an elderly parent whose spouse has died remarries late in life. And so now they have a relatively short length of a marriage with a new spouse, write a new will in the course of that marriage. The children maybe have been counting on dividing up their parents, singular, their parents' estate upon their death, but now suddenly they're having to share that with a new spouse. And there may be concerns that the new spouse has married the parent for the intention of making a money grab after death. The children would have to prove that their parent was unduly influenced by the new spouse. And none of those are easy. It happens. People can be successful with those challenges, but it's not easy. In terms of challenging a will, not only can you not challenge a will because it's unfair, there are also some time limitations. If somebody wants to challenge a will, they must begin the legal process within 2 years of the person's death. Challenging a will is difficult, it's a lengthy process, and it can be, as I suggested a minute ago, ultimately unsuccessful unless there is considerable and compelling evidence. And for those reasons, it's really important for anybody who's thinking about challenging a will to have legal advice before they start that process. If the person is in the end successful in challenging the will, most, if not all, of the legal costs will come out of the estate. And even if they're unsuccessful, if their case isn't unreasonable, they may be able to claim at least some of their legal expenses from the estate. And that's something else to be aware of. If, let's say, you're one of 3 or 4 siblings and you're feeling like you should have got a little more money from your parents' will than you did, you need to think about what it's going to cost you financially to challenge that will in comparison to how much difference it will potentially make to the amount of money that you get. You also need to think about the emotional toll on your family of challenging a will. What happens when someone dies without a will under Canadian law? This is called dying intestate, and those situations are dealt with under provincial territorial laws. In Ontario, the law I mentioned earlier, the Succession Law Reform Act, is the legislation that governs these situations. In each jurisdiction, the legislation sets out the sequence by which various people can inherit when someone has died intestate, has died without a will. A person who wants to make a claim in that situation must start a court process to set out the grounds for their claim, and the rules for that are set out in Ontario in the Succession Law Reform Act and in other provinces in the comparable legislation. Generally, if there's a spouse, that person gets most of the estate, followed by dependent children if there are any, and then other relatives. Only blood relatives, including children born both inside and outside the marriage, and legally adopted children, can make a claim against an estate when there's no will. Let's look at an example to try to make that a little more easy to understand. If person A dies and does not have a will, if they have a spouse, that spouse ranks first in terms of the people who get a share of the estate. If there are dependent children, meaning generally children who are not yet adults, there are some exceptions to that if the child is an adult but disabled and so on, Then the children come after that, whether they're children of that marriage or a previous marriage or children who were born outside a marriage. After that, there are other relatives who line up, siblings, parents if they're still alive, grandchildren, and so on. The bottom line is that when there's no will, it's a mess. And anybody, whether it's the spouse or the dependent children or relatives, more distant relatives, who wants a share of the estate has to go to court. You've got to get a lawyer and you have to go to court. In Ontario, the first $200,000 of the estate goes to the surviving spouse if there is one. If there's not $200,000 in the estate, then they get a percentage of how much there is. I believe it's approximately 2/3. So let's say in this made up story, there's $500,000. The first $200,000 goes automatically to the surviving spouse, automatically once the spouse takes the matter to court. And then the rest of it is split between the spouse and the children. So in this $500,000 estate, there's $300,000 left now, and the rest of that is split using a particular fraction between the spouse and any children. If there's neither a spouse nor children, the estate is shared between ever more distant relatives. The spouse in this situation, the surviving spouse, can take that money, the $200,000 plus a share of the remainder of the estate, or can take half the net family property under family law. It's so important for people to have a lawyer who are dealing with this and a good accountant, because it can be either a minimal difference between those two options, or it can be a huge difference. It's really important for people to be able to crunch the numbers, have a professional crunch the numbers and say, well, if you claim under the Succession Law Reform Act, you would get this amount. If you claim under the Family Law Act, you would get this amount. And then they need, after that, they need a good lawyer to help them deal with the matter in court. Bottom line, people should have wills. It spares a lot of trouble and anguish for their relatives after they die, who are already dealing with enough because of the loss of that person from their lives. I'm going to move on to talk about something that we don't cover in the brochures because we thought it would be interesting to touch on this topic, and it's not at all unrelated to wills, and that's the topic of powers of attorney. So here I'm talking strictly about Canadian and more specifically Ontario law. There's no comparison that we're offering here between two different systems of law. I'm sure many of you are familiar with powers of attorney. Perhaps when you prepared a will, your lawyer said, and we can do powers of attorney while you're here. That's very common. Powers of attorney are governed under provincial and territorial legislation. These are, powers of attorney, legal documents in which a person gives someone they trust, who's called the attorney, but they don't have to be a lawyer. In fact, they're almost never a lawyer. I don't know why that term attorney started being used, but that's what it is. So you create a power of attorney and you give somebody else, someone you trust, the right to make decisions for you if you're not able to look after those matters on your own. In Ontario, the legislation that assists the whole area of powers of attorney is called the Substitute Decisions Act. There's two types of power of attorney, a power of attorney for personal care and a power of attorney for property. Usually, people choose family members or close friends to act as their attorney in these contexts. It's important to, as I said a minute ago, pick someone you trust. It's also a good idea to pick at least one person who's younger than you. So many people pick their partner and an adult child, or their partner and somebody they trust who's somewhat younger, so that if the partner dies, because they're both older people, the power of attorney stays in effect. A little bit about these two different kinds of power of attorney. The power of attorney for personal care gives the attorney, remember, attorney doesn't mean lawyer here, gives the attorney the authority to make healthcare, housing, and other decisions related to the person's personal life if that person is mentally incapable of making those decisions. Healthcare decisions include such things as consenting or not consenting to treatment, but healthcare decisions do not include medically assisted dying. So if I have power of attorney for an aging parent, let's say, that power of attorney can stipulate that I have the authority to say no to treatment if my parent is not competent to make that decision on their own. But that power of attorney cannot give me the power to tell my parent's physician that my parent would like medically assisted death. And it's a very fine line, but it's also a very important line to be drawn between those two things. The treatment could be something like do not resuscitate, do not force feed, do not give treatment, do not use a ventilator. So it's a long list, obviously, of things that people could put in that. So the power of attorney for personal care has to be written when the person has the legal capacity to write it, obviously. And once it's written, it lasts unless they revoke it or they write a new one. So these are really, really important documents. They're not things that people should just do quickly without thinking about them. They will potentially have a huge impact on how things unfold for them should they ever become incompetent. Likewise, a power of attorney for property is really important. It gives the attorney, remember, not a lawyer, the authority to make decisions related to the person's financial affairs when that person's not able to do so. So there's a slight difference. For the power of attorney for personal care to come into effect, the person who's written it must be mentally incapable. The power of attorney for property can be used for convenience. So let's say I have to travel outside Canada for a year, but I need certain decisions to be made about investments that I have. I can write a power of attorney to give that power to my adult child, my spouse, a close friend. I can be perfectly competent, but simply unavailable. Okay, so I just want to make sure that people understand the distinction between those two. Power of attorney for personal care is only activated when the person becomes mentally incapable. Power of attorney for property can become activated for convenience. Or it could be that I'm unwell and not able to attend to my financial affairs for a period of time, or I could be permanently incapable because of, for example, dementia. Powers of attorney cease to have any legal effect as soon as the person dies, and wills only have legal effect once the person has died. Before I die, it doesn't matter what my will says. It doesn't mean anything. It becomes a useful document at the moment of my death. And the exact opposite is true for powers of attorney. No more legal effect the second that I die. A power of attorney grants a lot of power to another person. It's important to be sure that this is someone who's worthy of the trust that's being given to them. For this reason, while it is possible and legal for someone to prepare their own powers of attorney, and in fact, in Ontario, the provincial government has an excellent power of attorney kit online, it's still a really good idea to get legal advice before you finalize that power of attorney. So that's the end of the presentation for this afternoon. I'm hoping that you have comments and questions and that Omar will jump into the discussion at this point. I'm going to turn things over to Sabrine to coordinate.
Okay, thank you very much, Pamela, for that presentation. So the first question that we have is, what is a bequest?
What is a bequest? Is that
Yes.
the word you said? Sorry. A bequest is simply something, if you're talking about Canadian law, and perhaps you're not, so I'll just say this briefly and then turn it over to Omar. In Canadian law, a bequest is something that you put in your will. So I'm bequesting my diamond ring to my oldest daughter. But I think, Omar, bequests mean something a little bit different under Islamic law. Is that right?
It's not so much different as it is, as you said. It's more limited. It has uh, a kind of more restrictive area in which it applies. You cannot, but it means the same thing. It's what you put in your will. You just cannot put things that exceed. You're not supposed to put things that exceed one third, and you cannot write things in your will for people who are already legal heirs who will inherit anyway. That's all.
Okay,
Great.
thank you.
Okay, thank you both. So the second question is, to have a will, is it valid if we prepare it personally and ask two persons to sign it as witnesses?
Under Canadian law, yes, although it's really not recommended, because with a lawyer, the person can ask all kinds of questions, get answers. The lawyer can point out things the person might not have thought of. And I'm just also interested in the language. If we prepare it personally, each person should have their own will, even if they're a couple, and often they're what lawyers call mirror wills. So my will might say, for instance, that, if I, or when I die, not if, we will all die, when I die, I want everything to go to my spouse. And then under that, I would put the alternatives. If my spouse dies at the same time as I do, then, here's how I would like my property to be divided up. And then likely my spouse would write a will that was exactly the same, but a mirror. Everything that they have would come to me. So even though that's the case, you don't write a will as a couple. You would write your own will or have a lawyer write your own will. Certainly, if it was written, if it was signed by you, if you dated your signature, if the witnesses, they would have to sign their names, print their names, their contact information, and the date. That would be, in all likelihood, seen as a valid will, but it is not what I would ever recommend. I'm not trying to make money for lawyers here, but I think it's very important, especially if you've got multiple children or a considerable estate. It's very important to have a lawyer assist you in writing a will.
Thank you very much. The third question is, can you please explain the holographic will and its status in Ontario?
Yep, a holographic will is a legal will, and it simply means that the person hand wrote their will and signed it. So if I wanted to write a holographic will today, I could sit here at my desk, get out a pen and a piece of paper, and I would, just say, this is my holograph will. My name is Pamela Cross. I wish to give half my estate to this child and half my estate to that child. If there were any specific bequests, so using that word in the context of a will, I would say that I would like, my daughter to have this item of mine and my son to have that item of mine. And then I sign it and write today's date beside it. That is what a holograph will is, and that is legal in Ontario. Again, I don't think holograph wills are a great idea, except in some kind of dramatic emergency where the person knows that their death is imminent, they don't have a will, or perhaps they have an old will that isn't what they want anymore, and they have no opportunity to see a lawyer, then sure, a handwritten will that the person has signed is better than no will or better than a will they don't like anymore. But it's not as good as a will that's been thought through carefully and that has the benefit of legal advice.
Great. Thank you, Pamela. The next question is there a state where the female half share rule applies and people are penalized for not following that rule? To my understanding, the family members and or brothers make a decision on how the share is divided, and these days women get a full share. I did.
I believe that's a question for me. So yeah, as with many things having to do with private law, here, if the heirs decide amicably to divide the estate equally among themselves, the state has no business interfering with that. There is only an issue if there is no amicable agreement between, say, you have siblings, brothers and sisters, and they agree that they will each have the exact same amount. Nobody's going to go after them, regardless of. I'm not aware of any country where the state will monitor each inheritance and go after people for not following the Islamic rules. But in an Islamic state where the default is that a brother will inherit twice as much as his sister, the brother can sue if he's not happy. And I'm aware of more cases where brothers abuse that power than cases in which there is amicable resolution. I don't know what that exactly says about the nature of the human species, but this is kind of what this is my impression. But certainly, if the brothers and sisters decide this is how they want to go, they want to divide it equally, then it's nobody's business.
So I want to add a little bit to that, just to make it clear that if we're talking about a family that's in Canada, they have to follow the inheritance laws in Canada. So this isn't so much about the half share rule, but let's say a parent dies without having left a will. Certainly the adult kids can go into the home and divide up among themselves all of the stuff in the house. It's there, they can get their hands on it. Nobody needs to know about that. But the bank, for instance, isn't going to release funds to any one or even all of the children in an account that's in the name of their parents until they see the appropriate court documentation to authorize them to do that. If there's a house that has to be sold, there are similar hurdles to jump through and jump over. So I'm not disagreeing with what Omar said at all, just sort of adding the framework of how that would look in Canada, because people have to fit within the rules of what happens if there's no will. And obviously, if there's a will, then the will would be followed.
Thank you both very much. Omar, I believe this question is directed to you. The question is, I think the inheritance for adopted children depends on the Islamic country they live in and or the sect of Islam they practice. Is this true?
So I'm aware of one country, Tunisia, that has this is about adoption, right? Just to make sure. Yes, adopted child. Tunisia has a regime of adoption that has its own rules regarding inheritance. I honestly, I'm not aware of any other case. Maybe there's another case that I don't know about. The general principle in Islamic law, and this is very hotly debated, is that you can bring a child under your care, but they would not become legally, they would not gain the same status as a biological child. Now you can give them gifts as much as you want, but if you die and you've not written a will or anything, and the inheritance proceeds according to the Shara'i, the legal Quranic divisions, then the so-called adopted or the child that is not biological will not receive. This is kind of in the way the classical principles work. As with everything else, there are ways around it. You can provide gifts. You can just divide your wealth while you're still alive. This becomes an issue when a person dies, and the children or the people who survive them proceed to divide the estate based on the rules of the Quran. In that case, that's not a very good scenario for a child that is not a biological child.
And certainly under Canadian law, the same is true. If I want to avoid, well, there's good and bad reasons for doing it. Maybe I'm wealthy enough that I can dispose of much of my estate while I'm still alive. My children are younger, they're in greater need of some financial help now. I can see them enjoy the benefits of having quote unquote inherited rather than it all happening after I'm dead. Certainly that can happen. It's also a way to help avoid some of the what are called inheritance taxes, but really it's probate fees is the correct term in Canada. I could even put the name of the deed to my house in the names of my children, and then become in effect a tenant in my own home. You want to have a very high level of trust with your kids before you do that, because you certainly don't want to find yourself out on the street at 85 or something because you put your children's name on the deed and then they decided to turf you out and sell the house. And sadly that does happen some of the time. But I'm just adding or building on what Omar has said in terms of disposing of parts of the estate before death. There's nothing that says you have to keep all of your estate intact to be disposed of after your death. You can do whatever you want with your stuff while you're alive, and then the will speaks to whatever's left. And that's why generally a will is better if it's written to say something like, I wish half of my property to go to each of my children, as opposed to I want this amount of money to go to my children. Because what if you don't have that amount of money at the time that you die?
Thank you both for that. I think, Omar, this one is for you as well. This question reads, I think Fic Jafria allows a daughter to inherit entirely if she has no brothers, not in Sunni law. Can you clarify?
Yeah, if there are no brothers, then the daughter will inherit. If it's just a daughter, of course, the daughter inherits everything. If it's a daughter and parents, for example, when the formula becomes more complicated, I know there are kind of minor differences between different schools on exactly how the formula will work, but in most scenarios where it's a daughter alone or a daughter and parents or something like that, the daughter will inherit the majority of the estate. As Pamela mentioned, the half share issue becomes an issue if there are a male and a female within the same category. So if there is a daughter and a brother, then it becomes an issue. But if it's just a daughter, then the daughter will inherit the vast majority of it.
Thank you very much. So straight to the next question. This is a point of clarification. This person asks, for 330,000, only 110,000 can be discussed as inheritance. What about the remainder?
So that's something that I said, so I should try to clarify it. I was simply talking about the fact that, as I understand it, only 1/3 of the deceased's estate under Islamic law can be put into a will. The rest of it has to be divided according to Quranic provisions. But Omar, am I putting that correctly, or am I saying it wrong?
Yes, 1/3 can go, 1/3 maximum can be part of a will. The rest will be divided among the children, spouses, whoever survives the deceased.
Okay.
Okay, thank you both. Can the children be the witnesses who are beneficiaries of the inheritance?
Great question. I should have said that myself. No, nobody who's a beneficiary can be a witness to the inheritance. So anybody who's named in the will cannot be the witness.
Thank you very much. Testator, what does that mean?
I hate this word. So I'm the testator in my own will. When I write a will, I'm called the testator. Does that make sense, the way I said it?
Yes, it does.
Okay.
Will you recommend a holograph will, or can it lead to complications? And I think you've already answered this.
I think so.
Yeah. Okay, so the next question is, if I hold a woman always had let me try this again. If I hold as a woman always had a separate account from her husband, why does she have to include him in her will?
I'm not sure what the first part of that means, but to the question part, she doesn't. Nobody has to include anybody in their will under Canadian law. However, in the case of spouses, if I write a will if I have a spouse and I write a will that excludes my spouse, they can challenge the will and will in all likelihood be successful in getting a share of my estate. There will be exceptions to that. If there has, let's say my spouse is in jail because they've repeatedly assaulted me, or even worse, they've killed me, they would probably not be successful in getting a share of my estate. But in a less dramatic situation where I simply don't like my spouse very much, but they're still my spouse, if I can leave them out of my will, but they will probably be able to get a percentage of my estate if they go to court.
Thank you, Pamela. So the next question is, what if a person dies without a will, does not have a spouse nor children, but has siblings outside of Canada? What happens to their estates?
So this would come under the Succession Law Reform Act, and those siblings, regardless of where they live, would have to bring a case to the court in Ontario if that's where the deceased person lived, and they would then receive that money, or the value of the estate if there's no spouse and no children. I can't remember off the top of my head whether siblings come next or parents come next. So if the parents of the deceased person were still alive, they would also share in the value of the estate. But the short answer is that anybody who's listed in the legislation, the Succession Law Reform Act, can bring an application to the court to get their share of the estate if somebody dies without a will.
Thank you very much, Pamela. The next question reads, does it matter if your will was drafted and authorized in another country?
If the will is written, if it's signed, if it's witnessed, then it will have validity in Canada.
Thank you very much. In the case of intestate, does the division of assets after the first 200,000 include all children or only dependent children?
That's a good question. So go on to a question that Omar needs to answer while I do a little looking, and then I'll answer that question. Is there a question that can occupy Omar for a minute?
I'm sure there is. Let's see. Let me see. So this one reads, Omar, are we able to check Malaysia, what their laws are? Because there's a high rate of adoption there.
Yeah, I mean, I'm not a Malaysian lawyer, but yeah, I could check maybe after the webinar.
And just a follow-up on that, another person said, as I know in Iran, there is no restriction for adopted children to inherit from their parents. That's just a point of reference, so maybe we can double check that as well.
And I can answer the question now. So if somebody dies without a will, first of all, just to be really clear, nothing happens at all. The money just sits where it is, or the property just sits as it is. Nobody can take it out of the bank. Nobody can sell the house. Nobody can legally sell jewelry or the art. And anybody who believes that they should have a share of those assets would apply to the court. So let's not assume it's a horrible family. Let's assume it's a sort of nice family. And the spouse and the children, whether adult or underage, would apply together to the court to have the Succession Law Reform Act rules kick in. And then that first 200,000 would go, as this person has said, to the spouse. The rest of it would then be divided between the spouse and all the children, not just dependent children. So all children, even adult children. And just a reminder, if there's less than $200,000, obviously, then the calculation is done differently.
Thank you very much, Pamela.
Can I just say something, Sabrine, if possible? Yes. So in response to the questions about inheritance of the adopted child, one of the might say positives between quotation marks of not having a designated share of the inheritance in the Quran is that you can include a child, that you care for into your will. So, if you, for example, give a house or a car or something to that child, and the value of the bequest does not exceed 1/3, then it's a valid bequest. Just to mention that.
Thank you very much for that clarification. I'll jump into the next question. So does the law require us to have executors to execute the will?
Yes, a will has to say that you're like a formal will. A holograph will can be much more relaxed. And really the idea of a holograph will is, as I suggested earlier, it's an emergency and death is unexpectedly imminent. But normally, if I can use that word, when somebody has a will prepared by a lawyer, it has to include a clause that says, here's who's in charge of sorting all of this out after I'm dead, and that person is the executor.
Thank you, Pam. So the next question reads, are there any instances where one's estate goes into possession of the government if a will is not written?
I know this is a fear that many people have, and the answer is not very often. Everything gets frozen when there's no will, meaning, as I said a minute ago, nobody can suddenly go into the parent's bank account or investment account or take money out unless their name is also on the account. But as long as there are people who rank, so spouse, children, parents, siblings, and so on, who become aware that the person has died and bring an application in Ontario under the Succession Law Reform Act, that money will eventually find its way to them. There are fees that have to be paid. It's more complicated. It's more expensive than if there had been a will. So it's just always better to have a will. But the money doesn't go to the government just because there's not a will. A lot of steps would have to be taken, and there would have to be an almost complete failure or a complete failure to find anyone who should inherit before the money would roll over. And at that point, the government would take it, but it doesn't happen very often. In fact, let me put that differently. It almost never happens.
Thank you. If you have a property in your native country where your parents are staying at, or the property is vacant and you get to use it only during your visits, do you have to include that property in your Canadian will?
No, I'm not sure what's going to happen to it in that other country, but you certainly are not required. You can leave anything you like out of your will. It just creates a bit of a mess for the people who are still alive to figure out what to do with it.
Thank you. What happens if the will directives are in conflict with family law? For example, a married man or woman wills his or her entire estate to the children and nothing to the spouse. Can the spouse contest the will? Would he or she win?
Yes, and probably. Certainly where a spouse has not been taken care of in the will, that person can contest the will, or they could bring an application under family law for a share of the estate, and they would in all likelihood get at least some of the money. Now, again, there are some, not exceptions, but there's some situations where the person might not be successful. If they're still married, but they've been separated maybe for many years, if there's some history of abuse or bad blood between them, it could well be that they're less successful. But the process is to meet with a lawyer, discuss whether it's better to contest the will or bring an application under, in Ontario, the Family Law Act. And then you put your evidence together. This was a complete surprise to me. We were still living together. He led me to believe, or she led me to believe, that I would be in the will. I'm depending on that inheritance in order to survive myself, and so on.
Thank you. So if the father died intestate and properties are all in a Muslim country and the children are all Canadian, how can the daughters get fair treatment from their brothers?
I think that's for you, Omar.
Yes.
Well, I think I guess that would depend on each country. Again, Tunisia is a notable example of a place where the law allows for equal division of the property. But the simple answer is reach an agreement. Have an agreement. The heirs should agree together on exactly how to divide the property and proceed in that way. I mean, I'm sorry, I can't provide anything more specific than that. The law of each country and the process that you have to follow in each country will differ, but the best way to go about it is to I'm not sure if Pam, it's if there's a way to kind of ensure internationally that these rights are protected or not, but absolutely the best way is to do it amicably, I think.
Yeah, I don't think there is, Omar, especially if it's the parents' property and they reside in another country and the property's in another country. It's going to be pretty difficult for Canadian law to reach out and overrule the way things would happen in that country.
Thank you both. So this question is, can brothers can dispose of properties as they want? Question mark.
I feel like that's part of the previous question. It's the same person,
Oh,
right?
Okay, so then we could just continue on then. Unless, Omar, did you want to add anything to that?
I thought that was maybe a follow-up to something I said, that it's, about amicable division.
Yeah.
And if that's the case, then the answer is yes, of course. Once the estate is divided, this becomes their property, and they can do whatever they want with it. They can gift their sisters as much of their share as they like. It's nobody can fault them for that.
Okay, thank you. What is the average probate fees in Ontario, or does it depend on the value of the property?
It does. And because I don't practice in that area, I don't carry those numbers around in my head. It's not a standard fee. It's a percentage of the value of the property, and the percentage changes the greater the value of the property. But I bet you could find that out online pretty quickly.
Okay, great. And can I buy a property for my child and keep it as a trust for him or her? Is there any provision in law for that?
Certainly, anybody can buy a property and have it registered in their name, but in trust for someone else. Then you need to have a detailed trust agreement that sets out the terms of that trust. So let's say it's a minor child, a child who's 7. The trust agreement would possibly say that the deed would transfer into the child's name when they reach the age of 18, 21, 30, what have you. But also the terms in the meantime, who's living in the house, who's responsible for the maintenance of the house. If there needs to be a new roof, is the parent who's bought the house in trust for their child going to pay for the new roof? Who's making the mortgage payments? Who's paying the utility bill? Can the child live in the house with the parent? Can the child move in a spouse and their own family, and so on? So the important part will be in the details of the trust agreement, but the answer is yes, of course, a parent can buy a house and hold it in trust for a child.
Thank you. In Muslim law, is it not the case that the man's brothers inherit it if he does not have male children?
So the kind of basic answer to that is yes. I'm just going to say that in the division of Quranic shares outside of the will is an extremely complicated matter. Famously complicated, actually. So each case will be different, and there are people who spend their entire legal careers just memorizing those cases. But yes, as a general principle, in the absence of male children, the brother will inherit. The share will depend, of course, on who else is inheriting. If I remember correctly, for example, a daughter and a male brother case would be 2/3 for the daughter and 1/3 for the brother. And then if it's more than one brother, then they would share the 1/3. That's kind of, but again, each case is very different. But this is kind of my general recollection of that case.
Thank you, Omar. This question has been answered. So if a man passes away and what remains is his 2 daughters and a wife, and the person who passes away also has parents and 2 brothers, plus a sister, and does not have a will, how will his assets be divided? And it does not know if this is a Canadian family law or a Muslim family law question.
So under Canadian law, anybody who believes they have a right to inherit any portion of that person's estate makes an application to the court following the rules that are set out in the Succession Law Reform Act. And they should have a lawyer, absolutely should have a lawyer to do that.
Yeah, under Muslim law, same thing. There's no will. They would, to know the exact formula for a particular case. This sounded too complicated for my math abilities, but they would have to consult with a lawyer. Generally, there are specific shares. The mother, for example, the wife have specific shares, the father, and so on. You pay those portions. And then, the remainder is divided among daughters and so among the kind of the daughters and sons. But again, the exact math of each case, it has to be determined by a specialized Islamic inheritance attorney.
Okay. So the next question is, can the beneficiary also be the executor?
Absolutely, yes. And very often that's the case, especially where there's a family. Very often the oldest child is named as the executor, but they're also one of the beneficiaries. It's just that the witnessing that a beneficiary cannot do.
Okay. So this question says, in the laws of inheritance, does the half-share rule apply to the mother's will, or is it only for the father's will?
Yeah, it applies in regardless whether it's the mother or the father.
Okay. And can a will be used to treat child custody if there is a history of abuse? For example, a female would wish for a child to be placed with a safe relative instead of an abusive spouse.
So wills cannot dictate what happens with dependent children. You can certainly indicate in a will what your wishes are, but that doesn't dictate what will happen. Let's say that I'm divorced from my children's other parent, and they're still minors. They're 2 kids, 8 and 10 years old. If I have strong feelings that I don't want the children to live with their father, I can put that in my will. But if he wants to have the children, they would sort of automatically go first to him. And then anybody else who thought that it was better for the children to live with them would, now we move out of inheritance law and back into family law, would bring an application in family court for custody, and they would argue that it was in the best interest of the children to live with them. So their evidence would include my will. And in the will, I would have hopefully set out very clearly why I did not want the children to live with their father and why I did want them to live with this other individual. But there would have to be further evidence to that effect, like maybe the father never saw them while the mother was alive. They spent a lot of time with their mother's sister and her family. They lived close together. They could move in with the mother's sister without having to change schools, so on and so forth. But putting, excuse me, you can put your wishes about your children in your will, but they're not legally the final determination about what will happen. The family court will decide based on what's in the best interests of those children.
Okay, thank you. So we did speak earlier about buying a property for a child and holding it in trust. Does this include if the child is an adult?
Yeah.
Okay. Do we want to take one last question or should we just end it off now?
Well, I like this question. I can't answer it, but I think it's an important question. Somebody has said Hansen Trust for disabled child or mentally ill. A Hansen Trust is a really important legal construction that allows a parent to make a particular provision for a child who may be a minor or who may be an adult if that child, for any reason, is not capable of managing their own affairs. And anybody who has a child in that situation should speak with a lawyer. And if the lawyer doesn't bring up the possibility of a Hansen Trust, the parent should bring it up because it is really important and it changes a lot about how the will gets written. And that's everything I know about Hansen Trusts. Talk to a lawyer about it.
Okay, great. So thank you, Pamela and Omar, for facilitating that Q&A discussion. In terms of the evaluations, they will be emailed to you later on today. Please let us know how we did so that we can only get better. We also see that there's a few people here who are participating who are not chapter members. I sent a link titled Join CCMW if you are interested in joining a CCMW chapter. But we do want to thank each of you for participating in our inheritance webinar. We want to thank our facilitators, Pamela and Omar, for their excellent presentation. And we will be uploading the webinars on our YouTube channel and our website shortly, very shortly. So thank you all for your participation.
Thanks to all of you, and thanks, Sabrine, for all your facilitation.
Yes, Sabrine, thank you, and Pam and Omar. It's Nuzat here. On behalf of CCMW, we really appreciate the time and the participation of the facilitators and all of you who joined us. So thank you, and we hope to continue with webinars in the future. So stay tuned for further notifications. Thank you very much, and have a safe rest of the day and week. Thank you.
Thank you all.